Thank you, Madam Clerk. Good morning. Welcome to the March session of the Tennessee Court of Criminal Appeals here in Knoxville. Oral arguments are scheduled this morning and this afternoon and several tomorrow morning. My name is Robert Wiedemeyer. I'm from Oak Ridge, Tennessee, but I live in Nashville now and serve on the middle section. It's my honor and privilege to have two colleagues with me today who both serve on the western section of our court. To my right, Judge John W. Campbell Sr. from Memphis, Tennessee, and on my left, Judge Matthew J. Wilson from Jackson, Tennessee. Each side has 20 minutes to argue their case. We have a light system on the podium. If you're the appellant and you wish to reserve part of your 20 minutes for rebuttal, please let us know immediately when you come up to argue, because our clerk will plug that into the lighting system and it makes everything run a lot smoother if you let us know on the front end. We have read the briefs of the parties. The records are here in the building, but we have not had those assigned yet. So we are aware of the allegations and the arguments that are contained in the briefs. So if you want to tailor your arguments accordingly, that's fine. I think that's all the preliminary matters. A lot of you I know have been here before, and all of these rules and regulations are all familiar to you, but I think that's everything. Now, Madam Clerk, are there any preliminary matters?
No, Your Honor.
If you'll call the first case, then we'll get started.
State of Tennessee versus Jayson, Isiah Booker.
All right, good morning. Are you Miss Newton?
I am.
All right, the docket is correct. And do you want to, I know you've got a motion for us to recognize post-judgment facts. Do you want to argue your case and then go to that motion? We thought we would consider that motion as part of your argument.
Yes, that would be fine.
Okay, let's do it that way then. Go
Thank
right
you.
ahead.
I'd like to reserve 5 minutes for rebuttal. Mr. Booker's case is about a violation of probation where the trial court erred in 3 ways. The largest and most important error was that the trial court allowed unreliable hearsay at the revocation hearing, and the trial court also considered that in its decision-making, which is where we get the second and third errors, which is that the trial court abused its discretion in finding that Mr. Booker had violated his probation and in sentencing him to 1 year in local confinement. We believe that because Mr. Booker had his confrontation rights violated and that the judge misapplied the law in doing so, that Mr. Booker is entitled to a reversal of the trial court's decision. So Mr. Booker was on probation. He had pleaded by information in a possession of marijuana case. He was on a 3-year sentence that had been suspended, but it had a 35% service rate. He had pleaded up a range as a range 2 offender. And the instant violation arose out of a November 10th, 2022 arrest. The violation of probation warrant alleged that there were 2 grounds for the violation: that he had picked up 6 charges and that he'd been in possession of illegal narcotics at that arrest. At the revocation hearing on January 25th, 2023, the state called 1 witness, and that was Christian Pickett with the Knox County Sheriff's Office. Officer Pickett testified that on November 10th, 2022, he arrived at the Oyo Hotel because there had been an officer involved in a foot pursuit. He testified that when he arrived, he observed Mr. Booker, Mr. Goins, and Mr. Eskridge already detained in the parking lot. He Officer Pickett testified that he had a brief conversation with Mr. Booker, and that Mr. Booker said that he had been in a room in the 200s, and then that he had moved down to room 112. And he said later that Mr. Booker originally stated the three of them were in a room in the 200s, and then that he was with his buddies in room 112. However, on cross-examination, Officer Pickett admitted that Mr. Booker did not say he came from room 112 that night, nor was the room 112 in Mr. Booker's name. Ultimately, Officer Pickett got a search warrant for room 112. He executed the warrant and found evidence of illegal narcotics, suspected illegal narcotics. Nothing in the room could be tied to Mr. Booker, which is not the case for Mr. Goins and Mr. Eskridge. However, in connecting Mr. Booker to room 112, Officer Pickett relied on unreliable hearsay from two different sources. First, Officer Pickett testified that Mr. Goins and Mr. Eskridge corroborated that the three of them were in room 112 together. I objected for confrontation clause issues, and the court overruled, saying, and I quote, "The court does find there's two grounds this would be admissible. One, a statement of a co-conspirator. Also, in a revocation hearing, reliable hearsay is permissible. The court does find the testimony of Investigator Pickett is reliable and therefore will allow it." Next, Officer Pickett testified that a woman named Miss Norris, he did not testify to her full name, who had been in a room next to room 112, he did not testify the exact room, had identified or had said that the three of them had been staying in that room. I again objected for confrontation clause issues. The court again overruled, saying, and I quote, "The court does find those are statements that are made to Investigator Pickett and does find that they are reliable given the circumstances." Ultimately, the court considered the unreliable hearsay in making its decision to find Mr. Booker in violation of his probation. The state did not call any additional witnesses, and the state did not independently corroborate anything that Officer Pickett said. In fact, Officer Pickett testified that he had not been wearing a camera, and he wasn't sure of the names of any other officers who might have heard the conversations that he is alleged to have had with the three arrestees. The court noted in its finding that the hearsay was obviously reliable from individuals, or one individual at least, who was in a neighboring room. And while the court also said that the defense had an interesting point about there being a lack of nexus between Mr. Booker and the alleged illegal activity coming out of room 112, the court still said there was a preponderance of the evidence that Mr. Booker was in violation of his probation.
Well, let's take the hearsay. Let's talk about the reliability issue first. Okay. The court said it's reliable, but also said co-conspirators perhaps meant statement by the co-conspirators, because it's really not a statement in furtherance of the conspiracy under that exception. But how is it not statements against interest? Even though the rules are relaxed in such a hearing, how does that not make it reliable?
Do you mean the statement that's allegedly by Mr. Booker being a statement against interest?
No, I'm sorry, the individuals, so the two others that were in the room with him.
So I believe that confrontation rights encompass hearsay rights. And the fact is that there is a standard that the Supreme Court says that courts have to follow in violation of probation proceedings, where there's a two-part consideration to getting in confrontation, to getting in testimony that would preclude or infringe upon confrontation rights. First, there has to be a good cause to justify the denial of the defendant's confrontation rights. And secondly, there must be a showing that the hearsay is reliable. And that's what the Supreme Court said in Wade. So my position is that regardless of if it were a statement against interest or any other hearsay argument, that does not mean that Mr. Booker's confrontation rights can be ignored, and the state completely bypassed that two-part test. So there was absolutely no inquiry or finding about good cause to allow in the statements from Mr. Eskridge and Mr. Goins or Ms. Norris. There was no proof that the state had independently tried to secure that testimony from those individuals themselves.
Stop for just a second, because I want to make sure I understand. Wasn't there testimony that Mr. Booker admitted to being with these two individuals in room 112?
So, Officer Pickett initially said that Mr. Booker said he had been with his buddies in room 112. And then upon cross-examination, he admitted that Mr. Booker did not say he came from room 112 that night. That's an inconsistent statement, which, in my opinion, negates his first statement. The trial court specifically liability of the original declarants, and I believe that's the key issue in that situation.
Well, doesn't that go back to what Judge Wilson was talking about, is that they gave statements against interest, these two individuals. That's kind of part and parcel of it, though. You have a situation, though, it's one thing, if you have an individual says, he was with us, and yes, we were, there was dope and guns and everything else in here. They're admitting that they are involved in criminal activity. That kind of was the standard, or one of the things you could consider for reliability, is that somebody wouldn't lie to get themselves into trouble. Someone wouldn't lie to make themselves subject to maybe felony arrest. And so it gives them an indicia of credibility, because a normal person wouldn't lie to get themselves in trouble. That was kind of the rationale. And in going back to what we have here, we have two individuals who pretty much don't do that. We were involved, and yet he was with us. And again, we're dealing with basically a preponderance standard, right, when it comes to determining criminal liability, whatever it is, at a hearing like this, it's by preponderance.
That's true, and I would like to note, probably at this time, that I had filed that motion for the court to. I'm not saying that he knew that something was going to happen that didn't happen yet, but I think that it goes to the validity of the underlying arrest and the underlying.
Let me stop you there, because I saw your file, and again, it's just the dismissal order. Motion to dismiss warrants. It just says moves to dismiss the following warrants currently pending. Now, that doesn't mean that the state feels that the crime hadn't happened. It could have just been it didn't happen, so we dismissed it. And that's the problem I have with this post-judgment facts, because A, how could it affect the judge's discretion when it didn't exist, and B, you're inferring that the state dismissed this because they didn't feel like it was a valid charge, and I don't think we can make that jump.
And I understand Your Honor's position. I believe that, speaking just of the record that we have before the court today, that there is not enough reliable evidence in the record to connect Mr. Booker with the criminal activity that came out of room 112. There's absolutely no law enforcement observation of him in room 112. There was nothing found in room 112, per Officer Pickett's testimony, that could connect Mr. Booker to room 112. And ultimately, Officer Pickett said that the only observation of Mr. Booker at the hotel was him walking out of a side door at the same time that Mr. Eskridge and Mr. Goins were walking out of the door, and then being in the parking lot. I believe that there's not enough there, that there were bare assumptions that cost Mr. Booker a year of his life, and he was deprived of the ability to cross-examine witnesses whose testimony the court considered in depriving him of 1 year of his life, which I believe was not justice, was not the right way for things to have happened in his case. I have 13 seconds remaining, and I don't know if I'm going to hand over the mic.
All right. Thank you, Ms. Newton. Good morning, General.
Good morning. May it please the court, Catherine Redding on behalf of the state. I will first address the motion to consider post-judgment facts. I don't think that it's necessary for this court to consider these facts. First, it's the state's position that these facts do not affect the positions of the parties. This court has said repeatedly that revocations can be premised on allegations in a warrant, even if the underlying charges that are the basis for the warrant are dismissed, or even if a defendant goes to trial and is acquitted of those charges. So I don't think that it is necessary to consider those facts given kind of the standard for consideration of post-judgment facts. And Judge Campbell, to your point, I think that it is difficult to tell why these warrants were dismissed, given all we know is the state moved to dismiss them. That could have happened for a variety of reasons, and without more, it's hard to know what the basis was, but even if we did know what the basis was, Mr. Goins and Ms. Nora testified about those hearsay statements at the revocation hearing, and the defendant was able to cross-examine inference that you can draw that they're not going to be witnesses, and the fact that she had an opportunity to observe what was happening offenses. It is clear that law enforcement found almost 10 pounds of revocation hearing would not have been different. A firearm, 5 mushroom bars, 1 or 2 bottles. We also have the hearsay, 3 hearsay statements from
It's in the record that, I guess,
Mr. Pickett said that he didn't find anything belonging to the defendant. Mr. Pickett said that he didn't find anything belonging to the defendant, like his driver's license of confinement. The state will ask this.
That Mr. Booker was going to be serving some period of confinement.
Granted another period of non-custodial probation or whatever it was. The judge did not make him, he made him serve a little time.
30 days.
Yeah, but then put him back on probation.
Yes,
Then you had this pop up, and he's going to be put back on probation.
yes.
Okay, so clearly the court considered all the options and then came back and made a decision that was clearly within the range of options he had.
So I don't know what the court considered options, and I understand that to be skirting the. I would like to address the argument about harmless error in this case. As I've noted before, the trial court did not give any consideration to Mr. Booker's alleged statements about. And then on cross-examination, he admitted that Mr. Booker never said he'd been in room 112 that night. I don't think that the trial court itself relied on that testimony about Mr. Booker to put Mr. Booker in that room. And therefore, I don't think that the trial court should have considered the unreliable hearsay without having taken the test, the test that the Supreme Court said that we have to take in Wade. That's the current law. Thank you.
All right. Thank you, Ms. Newton. We'll consider the motion along with the record on